I'm joined on this Google Hangout by a professor of law with the University of Missouri. Brad Desnoyer is our guest. And Brad, thank you very much for joining us for a few minutes.
Thank you, Mike.
We're going to be talking about the transfer law situation. Of course, as Brad and I speak, as the professor and I speak, we're still waiting on action from the governor's office on the proposal that came out of the state legislature last week. And that was to change Missouri's transfer law. It did include what has been called the private option, a provision that would allow some tax dollars to go to private schools under certain circumstances. And that is one section that the governor has seized on, is saying he's got some issues with the law. And Brad, maybe before we get into that, suffice to say there are other sections of the law he's got to evaluate. There's more to it than the private option for him to decide whether or not to veto that bill, right?
There is certainly a lot in this bill. There's a lot of things that have changed. One big thing being, of course, that the transportation issue is now changed, and that students will have to find their own transportation to get to these schools, rather than having the school like Normandy now busing the students to those other districts.
So we don't want to suggest that there aren't other factors, but what I contacted you to talk about then is specifically the constitutional issue, and the governor has said that it would violate the Constitution to proceed with that private option. Some of the backers of the law have said that they believe the Constitution only prohibits tax dollars from going to religious private schools. You've looked at the sections of the Constitution, specifically the ones that the governor's office cites. Pick apart some of those sections and tell me what your opinion is about how they apply.
Well, there are three sections the governor's office has, and I would suggest there's actually a fourth that the governor's office has not looked at, which might actually be their best option if they want to have a reason for vetoing it. According to them, Article 3, Section 38 states that the legislature, the General Assembly rather, has no power to grant public money to private institutions or people. It's hard to determine what that really, if that really does apply to the situation. That has been used in the past, upheld statutes that have given money to private institutions if they are for public purposes. You could argue this is a public purpose, this education. Court cases have held that before. The same goes for Article 10, Section 3, which says taxes must be levied and collected for public purposes only. And it's debatable what a public purpose is, I guess you could argue. On its face, the best argument is, of course, that sending money to non-sectarian schools is still a private purpose. But I'm sure that the backers of the bill will argue that it is now a public purpose, since they're educating public students in their buildings. And so that's just something we'll have to see how the court interprets it, because that really does just come down to a matter of interpretation of what is this public purpose. And I think that goes to a larger point about this, something that backers of the bill, like the Show Me Institute, are really pushing, which is the idea in their mind that public education is any education to Missouri students. And I think one of the things they might be trying to do here is, hopefully for them, they want the court to come out and say, this is all of this is public education. Private schools is public education. As long as we're educating Missouri students, public education is an idea, is a talking point they have. It's an idea, not a district. And I think they're trying to push for that. They also talk about, now the governor's brought up Article 9, Section 5, which is a safer bet for the governor's office, which states that the proceeds of everything that comes to the state school fund shall be used for public schools only, and no other purposes whatsoever. And that's their safest bet, because that means that no state money can go to private schools, as long as they're non-sectarian. You could argue that that would be fine, but this says no purposes whatsoever. So even non-sectarian schools can't receive money. Now, backers of the bill have argued that they're only using local tax money. Therefore, no money from the state school fund is going to the schools. So that really comes down to the question of, how is the money getting to those private schools? Is it from a direct transfer from the unaccredited schools? They are directly writing a check to the private schools and handing it to them. that would certainly strengthen the argument for the backers of the bill. Or is the money first being collected, going to the state, held, and then distributed? Which at that point you have these tangible funds and you can't really track what money is levied and what money is the state. So it depends on how the money is really going to the districts. But even with that, you can make an argument that the levy, the way they proportion, the state proportions money to a school is based on the number of pupils it has and based on the way it collects its levy. And so that might impact the schools who are unaccredited. And thus you could argue that their state school fund is not being given to them the way it should be, and instead is being withheld from them, and they're having to spend the money they should be getting from the state school fund to send it to private schools. But Article 9, Section 11G is what really, I think, is important here. And that's a very small constitutional provision most people don't know about, which deals directly with the schools of Kansas City. And according to that provision, let me get the exact language here.
Which one are you looking up? And I'll pull it up for our viewers here.
So it is Article 9, Section 11G.
Okay.
Sorry, excuse me, Article 10, Article 10, Section 11G. And it's kind of hidden in there, but it says, and this is referring purely to the Kansas City school districts, because it says the school board of any school district operating levy for the school purposes of the 1995 tax year was established pursuant to a federal court order. That's Kansas City School District, due to desegregation orders they've had. May establish the operating levy for school purposes for the district at a rate that is lower than the court-ordered rate. If you take that apart, it says that the operating levy must be for school purposes for the district only. So it includes charter schools. Charter schools are public schools. So this is all fine with sending students to charter schools. It comes down to sending students to private schools. This says that in Kansas City, the operating levy is for schools of the district. So I think right there you have a problem, because you can't be sending money in Kansas City to private schools. And the governor's office, I guess, has not looked at that, but they really should. And so should the people who wrote the law. What is interesting, I think the people who wrote the law really did try to craft this in a way to make it constitutional, at least appear constitutional, and that they said it was only local tax levies that would fund this. And they got rid of the busing. Now, you might say they got rid of the busing for numerous purposes, but one reason to get rid of the busing is if they included the busing, well, then it's unconstitutional, because you can't bus students to private schools. That is unconstitutional. We know that. So if we're being cynical, the reason they got rid of that provision was to put in the school choice provision, the so-called school choice provision, which is very fascinating.
All right, so obviously it's a lot of moving pieces, a lot of things that are connected here, and so it's not a simple, maybe not a simple question, but when you come down to it, it really doesn't matter. I mean, the governor's office can veto it really for any reasons he wants to, right?
Right. Of course, he can veto for any reason he wants. The question comes down to if he doesn't veto it. Normandy filed a lawsuit today about the constitutionality of this piece of legislation. So it really is interesting to see what's going to happen. The whole problem with all of this, of course, is just that the students are still in flux, right? None of this actually will solve the problems, and we'll have lawsuits for years. And even as a lawyer, that upsets me, because this is something that just needs to be resolved, of course, and instead we have people, special interests on all sides, just trying to push their own agendas instead of helping the kids, which is it's kind of sad.
Not what I called you to talk about, but let me ask you, if this is vetoed and a special session is called, how do you see a special session playing out? Can we really expect a different result with the same lawmakers and the same legislature working on it?
That's a really great question, because for so many lawmakers, the selling point of this bill was the private option. Maybe if they're pushed at this point, that they will have to do some sort of fix and will allow it without the private school option. But I would imagine that nothing changes if there's some sort of special session. Gets vetoed. I don't see how they could come to some resolution now, especially now that there's a Normandy has been now taken over by the state. Again, so much is changing. It's just hard, and it really just puts into perspective how much this transfer law has uh, put the lives of all these students in flux. And instead of focusing on the real issues, which is the fact that 30% of the students in Normandy are functionally homeless. The fact that poverty rates are so high and reduced lunches are so high. We're never dealing with the underlying causes here. We're just putting on band-aids and saying, "Oh, look, we care," instead of actually addressing the real issues.
And I'm sorry, go ahead.
Oh, that's something I don't think that the legislators have any interest in dealing with, at least not a special session.
As someone who's been following the issue too, I think it's important that people watching this understand what the need for some action is, because if this law, if the changes in this law or anything else, if nothing changes before the next school year starts, where does that leave not just Normandy and Riverview Gardens, but there's some other school districts out there that are kind of teetering on the edge, aren't they?
Yeah, we have Kansas City, the southeast of Missouri. They have a lot of schools there. And again, why are we worrying about transferring a few students instead of fixing the actual schools and making them accredited? It's going to be a lot harder to get those schools accredited when you're taking their money away from them and sending their students to other schools.
All right, so we tried to cover all the issues there, but again, it's just a matter, Professor, isn't it, of wait and see. We're like everyone else, waiting to see what the governor does.
Exactly.
All right, Professor Brad Desnoyer has been our guest. He is with the University of Missouri School of Law. And what we're going to do for our viewers' sake is we'll post some of the links to some of these different provisions of the Constitution we've discussed here. We'll post those with this video and with this story. And Professor, thank you for your time today.
Thank you, Mike. I appreciate it.
This has been Mike Lear from Missouri Net.